Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Lesson 32. Don't forget to like, subscribe, and ring that notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. Stick with us and we'll get you through this test. Question number 1. A grand jury returned an indictment charging Daniels with bank robbery, and when he could not make bond, he was jailed pending trial. He had received Miranda warnings when arrested and had made no statement at that time. The prosecutor arranged to have Innes, an informant, placed as Daniels' cellmate and instructed Innes to find out about the bank robbery without asking any direct questions about it. Innes, once in the cell, constantly boasted about the crimes that he had committed. Not to be outdone, Daniels finally declared that he had committed the bank robbery with which he was charged. At Daniels' trial, his attorney moved to exclude any testimony from Innes concerning Daniels' boast. The motion should be A. Granted, because Daniels' privilege against self-incrimination was violated. B. Granted, because Daniels' right to counsel was violated. C. Denied, because Daniels had received Miranda warnings. Or D. Denied, because Daniels was not interrogated by Innes. Take 10 seconds and choose the best answer now. If you chose option B, granted, because Daniels' right to counsel was violated, you'd be correct. The Sixth Amendment provides the right to counsel at all criminal proceedings. It applies once the defendant has been formally charged with a crime and prevents the police from obtaining an incriminating statement after formal charges have been filed outside of the presence of counsel without first obtaining the defendant's waiver of counsel. In this case, Daniels has been formally charged with bank robbery. As such, Daniels' Sixth Amendment right to counsel would apply, which again prevents the police from obtaining an incriminating statement outside of the presence of counsel. The police, however, placed Innes in Daniels' cell and instructed him to find out about the bank robbery without asking any direct questions about it. By placing Innes in Daniels' cell and having Innes constantly boast about his crimes, the police were deliberately trying to elicit an incriminating statement from Daniels. As such, Daniels' motion should be granted because his Sixth Amendment right to counsel was in fact violated. Question number 2. In a signed writing, Nimrod contracted to purchase a 25-foot travel trailer from Trailco for $15,000. Cash on delivery no later than June 1st. Nimrod arrived at the Trailco sales lot on Sunday, May 31st, to pay for and take delivery of the trailer, but refused to do so when he discovered that the spare tire was missing. Trailco offered to install a spare tire on Monday when its service department would open, but Nimrod replied that he did not want the trailer and would purchase another one elsewhere. Which of the following is accurate? A. Nimrod had a right to reject the trailer, but Trailco was entitled to a reasonable opportunity to cure the defect. B. Nimrod had a right to reject the trailer and terminate the contract under the perfect tender rule. C. Nimrod was required to accept the trailer because the defect could be readily cured. D. Nimrod was required to accept the trailer because the defect did not substantially impair its value. Take 10 seconds. If you chose option A, you'd be correct. Nimrod had a right to reject the trailer, but Trailco was entitled to a reasonable opportunity to cure the defect. Under the UCC, the perfect tender rule allows a buyer to reject all goods that are not exactly as promised in the contract. However, the seller has the option to cure if the time for performance has not yet expired. Here, Nimrod had a right to reject the trailer on May 31st because its missing spare tire was not a perfect tender of the 25-foot travel trailer. However, Trailco had until June 1st to deliver the trailer per the contract, so Trailco had time to cure and install a spare tire. Accordingly, Nimrod had a right to reject the trailer, but Trailco was entitled to a reasonable opportunity to cure the defect. Question number 3. Mr. Denby was charged with the sale of narcotics. The federal prosecutor arranged with Mrs. Denby for her to testify against her husband in exchange for leniency in her case. At trial, the prosecution calls Miss Denby, who had been granted immunity from prosecution, to testify against other things that she saw her husband sell an ounce of heroin. Which of the following statements is most clearly correct in the federal courts? A. Miss Denby cannot be called as a witness over her husband's objection. B. Miss Denby can be called as a witness but cannot testify over Mr. Denby's objection that she saw him sell heroin. C. Miss Denby can refuse to be a witness against her husband. Or D. Miss Denby can be required to be a witness and to testify that she saw her husband sell heroin. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. Miss Denby can refuse to be a witness against her husband. A spousal witness is permitted to refuse to testify against his or her spouse as to anything. Under the federal rules of evidence, this privilege only applies in criminal cases, and the witness spouse holds the privilege. In this case, Miss Denby would be a spousal witness against Mr. Denby in a criminal trial. As a spousal witness, Miss Denby can refuse to be a witness against her husband. Therefore, C is the most clearly correct statement in the federal courts. Let's move on to question number 4. Test owned Blackacre, a vacant 1-acre tract of land in state. 5 years ago, he executed a deed conveying Blackacre to church for the purpose of erecting a church building thereon. 3 years ago, Test died, leaving Sonny as his whole heir at law. His duly probated will left all my estate, both real and personal, to my friend Fanny. Church never constructed a church building on Blackacre, and last month Church, for a valid consideration, conveyed Blackacre to developer. Developer bought an appropriate action to quiet title against Sonny, Fanny, and Church, and joined the appropriate state official. Such official asserted that a charitable trust was created, which was not terminated. In such action, the court should find that title is now in A. Developer, B. Sonny, C. Fanny, or D. the state official. Take 10 seconds. If you chose option A, you'd be correct. The developer. A fee simple absolute is the least restrictive present possessory interest, and it results in absolute ownership with potential infinite duration that is freely alienable. A defeasible fee is an interest in land that has the possibility of being taken away. The language granting a defeasible fee must be clear durational language. Words of mere hope, intention, expectation, or desire are not sufficient to create a defeasible fee. For example, to A for the purpose of is not a defeasible fee. Defeasible fees are generally disfavored by courts because defeasible fees are not freely alienable. Here, Test executed a deed conveying Blackacre to Church for the purpose of erecting a church building thereon. Test may have been trying to create a defeasible fee, but there's no clear duration language. Without clear duration language, there can be no defeasible fee. As such, Test is considered to actually have conveyed Blackacre in fee simple absolute to Church, because a fee simple absolute is freely alienable. Church was within its rights to convey Blackacre to developer for valid consideration. Developer then bought an appropriate action to quiet title. As such, in an action by developer to quiet title, the court should find that title is now, in fact, in developer. Question number 5. Dumont, a real estate developer, was trying to purchase land on which he intended to build a large commercial development. Perkins, an elderly widow, had rejected all of Dumont's offers to buy her ancestral home, where she had lived all of her life and which was located in the middle of Dumont's planned development. Finally, Dumont offered her $250,000. He told her that it was his last offer and that if she rejected it, state law authorized him to have her property condemned. Perkins then consulted her nephew, a law student, who researched the question and advised her that Dumont had no power of condemnation under state law. Perkins had been badly frightened by Dumont's threat and was outraged when she learned that Dumont had lied to her. If Perkins sues Dumont for damages for emotional distress, will she prevail? A. Yes, if Dumont's actions was extreme and outrageous. B. Yes, because Perkins was frightened and outraged. C. No, if Perkins did not suffer emotional distress that was severe. Or D. No, if it was not Dumont's purpose to cause emotional distress. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. No, if Perkins did not suffer emotional distress that was severe. The intentional infliction of emotional distress requires 1. An intentional or reckless infliction. 2. Of severe emotional or mental distress. 3. By extreme and outrageous conduct. 4. Actual damages. And 5. Causation. In this case, Dumont lied to Perkins by telling her that state law authorized him to have her property condemned. Perkins had been badly frightened by Dumont's threat, but the intentional infliction of emotional distress requires emotional distress of such substantial quantity or enduring quality that no reasonable person in a civilized society should be expected to endure it. Being misled in a proposed business transaction doesn't seem to meet this requirement of severe emotional distress, so Perkins will not likely prevail if she did not suffer emotional distress that was in fact severe. Question number 6. Daniel is on trial for evading $100,000 in taxes. The prosecution offers in evidence an anonymous letter to the IRS, identified as being in Daniel's handwriting, saying, "I promised my mother on her deathbed I would try to pay back taxes. Here is $10,000. I'll make other payments if you promise not to prosecute it." Answer yes by personal ad saying, "Okay," on tax deal. The letter is A. Admissible as a statement of present intention or plan. B. Admissible as an admission of a party opponent. C. Inadmissible because it is an effort to settle a claim. Or D. Inadmissible because the probative value is substantially outweighed by the risk of unfair prejudice. Take 10 seconds now. If you chose option B, you'd be correct. Admissible as an admission of a party opponent. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. One exception to hearsay is the admission of party opponent exception. An admission of party opponent is a statement by a party or by someone whose statement gets attributed to that party offered by the party opponent. An offer to settle is not admissible if there is a claim asserted and a dispute as to the liability or damages. Here, Daniel's letter is being offered to prove the truth of the matter asserted in the letter, i.e., Daniel owes back taxes. This is an admission of a party opponent because Daniel is being prosecuted by the IRS, so Daniel's letter is admissible as a hearsay exception. The letter will not be inadmissible as an offer to settle because there was not yet a claim asserted by the IRS. Furthermore, there was no dispute as to liability or the amount owed because Daniel seems willing to pay the total amount of back taxes. Thus, the letter is admissible as an admission of a party opponent. Question number 7. While walking home one evening, Harold, an off-duty police officer, was accosted by Jones, a stranger. Jones had been drinking and mistakenly thought Harold was a man who was having an affair with his wife. Intending to frighten Harold but not harm him, Jones pulled out a knife, screamed obscenities, and told Harold he was going to kill him. Frightened and reasonably believing Jones was going to kill him and that using deadly force was his only salvation, Harold took out his service revolver and shot and killed Jones. Harold is charged with murder. Harold's claim of self-defense should be A. Sustained because Harold reasonably believed Jones was planning to kill him and that deadly force was required. B. Sustained because the killing was in hot blood upon sufficient provocation. C. Denied because Jones did not in fact intend to harm Harold and Harold was incorrect in believing that he did. Or D, denied, because Harold was not defending his home and had an obligation to retreat or to repel with less than deadly force. Take 10 seconds. If you chose option A, you'd be correct. Sustained because Harold reasonably believed Jones was planning to kill him and that deadly force was required. A victim may use deadly force in self-defense if the victim is not at fault. The victim is confronted with unlawful force, and the victim reasonably believes that she is facing imminent danger or threat of bodily harm. The majority rule is that there is no duty to retreat. In this case, Harold was not the initial aggressor. Harold was confronted with unlawful force when Jones pulled out a knife and told Harold he was going to kill him. Granted, Jones only intended to frighten Harold, but the facts state that Harold reasonably believed Jones was going to kill him, and that using deadly force was his only salvation. Under the majority rule, Harold had no duty to retreat before using deadly force in self-defense. Therefore, Harold's claim of self-defense should be sustained because Harold reasonably believed that Jones was planning to kill him and that deadly force was in fact required. Now let's analyze B, C, and D. B. Sustained because the killing was in hot blood upon sufficient provocation. I have no idea what that is, and if you've been following criminal law well, you probably don't either. That's because it's not something that actually in fact exists and should be eliminated right off the bat. C. Denied because Jones did not in fact intend to harm Harold, and Harold was incorrect in believing that he did. The standard here is what did Harold reasonably believe. And in fact, the actual intent of the individual is not what we're looking at, nor is it the standard to follow. It is what Harold would have reasonably believed. As a result, C would be incorrect. D. Denied because Harold was not defending his home and had an obligation to retreat. We can stop right there. There is no obligation to retreat under these circumstances. So as a result, A would be the only possible correct answer. Question number 8. Doppler is charged with aggravated assault on VZ, a game warden. Doppler testified that when he was confronted by VZ, who was armed and out of uniform, Doppler believed VZ was a robber and shot in self-defense. The state calls Willie to testify that a year earlier he had seen Doppler shoot a man without provocation and thereafter falsely claims self-defense. Willie's testimony is A. Admissible as evidence of Doppler's untruthfulness, B. Admissible as evidence of Doppler did not act in self-defense on this occasion, C. Inadmissible because it is improper character evidence, or D. Inadmissible because it is irrelevant to the defense Doppler raised. Take 10 seconds. If you chose option C, inadmissible because it is improper character evidence, you'd be correct. The rule for character evidence in a criminal case is that no character evidence is admissible during the prosecution's case in chief. The prosecution can only rebut character evidence introduced by the defendant. Furthermore, on direct examination, only reputation and opinion evidence is admissible, whereas on cross-examination, any form of character evidence is admissible, such as reputation, opinion, specific instances. In this case, the state is attempting to introduce specific instances of Doppler's character on direct examination. Since the state can only introduce character evidence through reputation or opinion evidence on direct examination, Willie's testimony would be inadmissible. Question number 9. Perkins and Morton were passengers sitting in adjoining seats on a flight on Del Valle Airline. There were many empty seats on the aircraft. During the flight, a flight attendant served Morton 9 drinks. As Morton became more and more obviously intoxicated and attempted to engage Perkins in conversation, Perkins chose to ignore Morton. This angered Morton, who suddenly struck Perkins in the face, giving her a black eye. If Perkins asserts a claim for damages against Del Valle Airline based on negligence, Perkins will A. Not recover, because a person is not required by law to come to the assistance of another who is imperiled by a third party. B. Not recover, if Perkins could easily have moved out to another seat. C. Recover, because a common carrier is strictly liable for injuries suffered by a passenger while aboard the carrier. Or D. Recover, if the flight attendants should have perceived Morton's condition and acted to protect Perkins before the blow was struck. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. Recover if the flight attendants should have perceived Morton's condition and acted to protect Perkins before the blow was struck. To establish a prima facie case of negligence, the plaintiff must prove a duty, breach of that duty, causation, and damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect the plaintiff against an unreasonable risk of injury. The basic standard of care is that of a reasonable person acting under like circumstances. There is no duty to unforeseeable victims. The general rule is that a person does not have an affirmative duty to act. An exception exists, however, if there is a pre-existing relationship between parties such as common carriers and customers, like there is here. Here, Davao Airline is considered a common carrier, and as such, Davao Airline owed a duty to Perkins to protect her from an unreasonable risk of injury. If a flight attendant failed to act as a reasonable person of ordinary prudence in the flight attendant's position would have acted, then Davao Airline can be found liable for negligence. Morton had been served 9 drinks, which is no small amount. As Morton became more and more obviously intoxicated, a reasonable person of ordinary prudence in the flight attendant's position would likely have intervened in some way, perhaps by not serving Morton any more drinks or moving Morton to a different seat, especially since there were many empty seats available. However, the flight attendants did not act to protect Perkins, and she suffered a black eye when Morton struck her in the face. This was an unreasonable risk of injury to a passenger on a plane. Accordingly, Perkins will recover on a claim for damages against Davao Airline based on negligence if the flight attendants should have perceived Morton's condition and acted to protect Perkins before the blow was struck. Question number 10, the last question in this grouping. Shore decided to destroy his dilapidated building in order to collect the insurance money. He hired Parsons to burn down the building. Parsons broke into the building and carefully searched it to make sure no one was inside. He failed, however, to see a vagrant asleep in an office closet. He started a fire, the building was destroyed, and the vagrant died from burns a week later. 2 days after the fire, Shore filed an insurance claim in which he stated that he had no information about the cause of the fire. If Shore is guilty of felony murder, it is because the vagrant's death occurred in connection with the felony of A. Arson, B. Fraud, C. Conspiracy, or D. Burglary. Take 10 seconds. If you chose option A, arson, you'd be correct. Under the felony murder rule, a person can be found guilty of a killing that occurs during the commission of an underlying felony that's an inherently dangerous felony. For example, burglary, arson, rape, robbery, and kidnapping. The intent to kill is inferred from the intent to commit the underlying felony. In addition, the deaths caused during the commission of the felony must be foreseeable and must occur before the defendant has reached a point of temporary safety. Arson is the malicious burning of another's dwelling. Burglary is trespassory breaking and entering of another's dwelling at night with intent to commit a felony therein. Here, only A and D can serve as inherently dangerous felonies required from felony murder. In this case, Shore hired Parsons to burn down Shore's building, so Parsons was not trespassing when he entered Shore's building. Without a trespass, there is no burglary. Arson, however, is clearly shown by the facts. Therefore, Shore is guilty of felony murder. It is because the vagrant's death occurred in connection with the felony of arson. Congratulations on making it to the end of this grouping. Once again, this is Bar 10 test prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. So, to that end, don't forget to like, subscribe, and click the notification bell. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. We want to ensure that you're notified every time that we do. Good luck, and we're here with you for the long haul.